Good morning. Thank you for being here today for the 10th Court of Appeals at Sam Houston State University. We'll be hearing 3 cases today. This is a great opportunity for us to get to travel to see the folks in our constituency, if you will, since we are all elected in the state of Texas. And so it is good to travel, it's good to see, but it's really for you all, the opportunity for you to see a court of appeals that is hearing real cases where parties' interests are directly affected by the decision that we will ultimately make in these cases. Before we get started, I will tell you that a couple of things that are different than normal. If you came to our courtroom in Waco, where we are home based, we have 18 counties in our district. So if this is just one of those 18 counties, and we can sit for oral argument in the county seat of any of those 18 counties. And so that's why we are in Huntsville today. But normally, if you came to Waco and watched an oral argument there, we would not allow the attorneys to turn and speak to the audience. In a moment, when we call the case and the attorneys start, we are going to ask them to speak to you all directly for 3 minutes to give you either procedural or factual background for the case that allows you to understand the legal framework of the legal arguments they are going to be making to us that will affect the result, our decision in the case. The other thing that is different when we travel is that originally technology was such that any photographing of the proceedings was very distracting. Flash bulbs, people moving around, that kind of thing. A lot of changes have occurred in technology. If you do not use a flash on then it will be okay to photograph. We ask you not to move around during the proceedings to take photographs, however. If you do have an emergency that you need to leave, or if we run over too far into the class schedule and you need to leave, that's okay. But be respectful, because there is a very legitimate interest at issue in each of these cases, and we do not want to distract the judges or the parties. The pandemic also changed. It's been coming here every year at this time of year. And in the spring of 2020, I guess you could say life on the planet changed. And so we had to cancel our spring of 2020. We canceled our spring of 2021. But as a result of that, we had to learn to accommodate public access to a courtroom when they were not physically present. And so we started a process of publicly broadcasting on the YouTube channel our court proceedings, the oral arguments. Initially, they were actually the 3 of us would sit in our offices and do the oral arguments from there. Later, we held the argument in the courtroom, but we restricted access for all of those. We posted those on the court's YouTube channel. All of those arguments are still up and on the channel. Today's argument is also going to be broadcast, or is being broadcast as we speak, on that channel. It occurred to me just as I started, I failed to give it for today, so it will just be Judge Gray's Zoom meeting, and I apologize for that. But if you want to go back, it will be broadcast. The thing that I caution you all on is the technology that we now have that we're trying out for the first time for this argument is this device that's down here in front of me that's called an owl. There's a 360-degree panoramic view being shown of what's going on in here during the time that it's being broadcast. So it is broadcast and it has the 360-degree panoramic, and then it feeds on the vocal of where the speakers are, that if we ask questions, or the attorney that's doing the presentation. So be aware of that. At this time, I would like to acknowledge some folks. Do we have any LEAP ambassadors in the audience? LEAP ambassadors. We have one back here. These are the folks that are responsible for bringing us here. They coordinate us, they give us traffic. And so we don't normally give round of applause, but in this instance, I would like to give one to our leader. The leader of our leading group is Mike Yawn. He's the faculty member in the back with the camera. He is our host in a way. He kind of coordinates all this. Dean Lyon is the Dean of the College of Criminal Justice. He is the one who has vacated his office for us today. And so we are indebted to him for the opportunity and the place to meet. Judge David Moorman is on the back row. He's one of the district judges here in Walker County. And so David, thank you for being here with us today. And then also in the back row, Judge Tracy Sorensen is here. She's one of the county court of law judge here in Walker County and part of y'all's elected officials here in the district, and is the district clerk-elect Leslie Woolley here. We thought she might be here. And Judge Pierce. Oh, Pierce, I didn't get to see you before we started. I hate that you're retiring, but you know, Walker County has been in good hands for a very long time. Ladies and gentlemen, this is your county judge, Danny Pierce. He is a great guy, has been very supportive of our program here, as well as our involvement in the Walker County area. So Danny, thanks for coming out today. I hope you get to see you later. We have Officers King and Wells with us today, providing security since 9/11. That's been pretty much a necessary evil of our travels. And so thank y'all for the county having those here. How do you follow what goes on today? If you were expecting a jury argument, you will not see it. If you were expecting a witness and a brilliant cross-examination, you will not see it. This is an appellate court. That means that a district judge like Moorman or Sorensen has already rendered a judgment, and something about that judgment, one side of the thinks there was an error that affected that result. That is what you are going to see today, an appellate argument about why that particular judgment is wrong. We will hear the arguments today from the appellant and the appellee, and then we will go back to our home in Waco and we will study the briefs of the parties, the written submission. We will review the record that was prepared at the trial court proceeding, and then we will render a decision as to whether or not there was an error in the judgment that affected the error in a judge's ruling that affected that judgment. That's what we do if the parties are unhappy with what we do, and most assuredly one side or the other is going to be unhappy. Then they have the opportunity to present that case to the state's high courts, either the Texas Supreme Court or the Court of Criminal Appeals. To help us do our job, we have staff attorneys that are career attorneys that have worked for the court. They study the briefing and the case with us and then draft an opinion. To help me do my job, we have the court clerk to my far left, which is Nita Whitener. She is the chief administrator of the office that coordinates the filing and everything. But the crux of what we do is the panel of judges. There are 3 on the 10th Court of Appeals, and you're looking at the 3 elected judges. I've been doing this now for, some people would say too long, a couple of decades. We've actually been to the county since it was added to our district in about 08, 09. Mike and I are going to have to do some research into our history to figure out what the first year was. But the judges sit on the bench, other than the chief justice, it's a elected position in and of itself. They sit on the bench in the order of their priority of when they came onto the court. So if you look at an appellate court, you always know that the person to the right of the chief justice has been there the longest. And this is Matt Johnson, for January of 2021, been there now for 14 months. And so, but he was a district judge for 14 years prior to that in McLennan County. He also served as a briefing intern on the court before he was elected to the court. To my left is Justice Steve Smith. He came to us as a result of a retirement of a judge, gubernatorial appointment. He has to stand for election and was of this election cycle to run for the term that is coming up, 6-year term. And so all Steve has to do to be elected justice, since he was unopposed, is be here on January 1 and take the oath. So he will be here with us for a 6-year term. Gentlemen, have I forgotten anything before I call the document? Okay. At this time, we will call the first case, and I'm trying to remember if we set both of them at 10 o'clock. I think it was at 11. Nope, they're both set at 10. Okay, so I'll need announcements from the attorneys on the cases, and I will need to know if there are any preliminary matters that need to be addressed, such as exhibits that have not been shown to the other side, and there's an objection or anything of that nature. Let me know. Also, please let me know which attorney is going to be doing the argument if there's more than one particular. First case on the docket today is, counsel, can you help me with pronunciation?
Jennifer Korzynski.
Korzynski versus Cowboy Up Ranch Furniture.
Commissioner Sean Reagan and Carlos Leon for the plaintiff, Jennifer Korzynski. Mr. Sean Reagan will be presenting your order. And there are no preliminary matters that I'm aware of.
Okay, thank you, counsel, and you can go ahead and come up with the lectern and we'll get started.
Morning, Judge Dan McLemore for the FLE Cowboy Up Ranch, joined by Lauren Oliveira. I'll be arguing on behalf of the FLE this morning. We have no.
Okay, thank you very much. At this time, I'm going to turn it over to Counsel Reagan, and he will be allowed to come around on this side of the microphone or the lectern and turn and face directly to the audience and speak to them.
May it please the court. Good morning. This is a lawyers call a premises liability case. It's where a person who plaintiff sues a premises owner, a property owner, or someone who occupies a property for person they stay on that property. What happened in this case is our client, Ms. Korzynski, visited a furniture store in Calvert, Texas, in Robertson County. She went upstairs to the second floor to look at some artwork. And on the way down, she tripped and fell down the stairs, suffering concussion and other serious personal injuries that required surgery. Now, there are two main issues before today, the way we see it. The first is a jurisdictional question. Does the jurisdiction even hear this case in the first place? Jurisdiction means, does the court have the power or the authority to hear this case? And to give the best or give the court the power or the authority to hear this case, we as the plaintiff who lost in the trial court below had to file a notice of appeal within a certain time frame. If you missed the deadline, sure, all of you are probably aware, if you miss a deadline, there are some dire consequences. So one of the issues we're going to be talking about today, the deadline to appeal, to complain about the trial court's judgment, and to invoke this court's jurisdiction, to invoke this court's power and authority in your case, was filed late. Now, sometimes you have a good excuse for why you missed the deadline, and that's what we're going to be talking about today. And if you meet certain requirements, you can file your notice of appeal, file your complaint with this court untimely, and invoke the court's jurisdiction. So that's kind of the first bucket we're going to talk about, and that's probably the most important bucket to talk about, because if the court doesn't have jurisdiction, the rest of it doesn't matter. For authority to address the merits of ours. Now, as to the merits of ours, simply because under Texas law and probably the law of all 50 states, just because someone got hurt on your property, a property that you're leasing or occupying, that doesn't mean you're automatically responsible for litigations. The plaintiff would be us in this case. We have to prove something more than merely we just got hurt on your property. Now, the standard to how you prove it depends on separate categories. Faster, or you divide it on the property. So, in this case, it's going to be understood that we're in what's called in the right. The three sub-issues about the merits of the case, whether the store has liability to Ms. Korzinski, could have been on whether or not the condition was quote unquote open and obvious. The plaintiff, if something's open and obvious, you can't step in the hole and claim you were injured. Another issue is like, was the conditions we're complaining about, were they unreasonably dangerous? If they're unreasonably dangerous and others, the rate, if the furniture store knew about it or should know about it, they have a duty to eliminate the risk or mitigate the risk or warn you about it.
Council, your 3 minutes is up, so it's time to talk to.
Sure.
May it please the court.
You may.
As I said, the first issue I want to talk about, the threshold issue, is the jurisdictional issue. It is undisputed that the notice of appeal was untimely. I filed a Rule 36A motion to extend the deadlines for filing our notice of appeal, filing our motion for trial, which the trial court considered the evidence and granted. Now, the dispute here, reading the briefs again this past week, seems to be, does Rule 306A control that was the clerk required to send the notice of the judgment by first-class mail? Or does check the later enacted Chapter 80 of the government control, which says the clerk may send the notice of judgment by electronic means, including email. And I know in February, the Supreme Court adopted a proposed amendment to Rule 306A to change the language from first-class mail. The clerk is required to get notice of the judgment by first-class mail or electronic means. So this may be the last time this issue comes up. But I think the Supreme Court adopted that rule to resolve the conflict between the other rules of civil procedure, including Rule 21A, Rule 21, which provides, like Rule 36A, that all notices have to be given to the. So I don't think we have to get to resolving any conflict between Chapter 80 and Rule 36A, because either standard that applies, it's going to be undisputed that the notice wasn't properly given. So in the Cowboy concedes in the brief that the source of the clerk's duty to send the notice of the judgment is Rule 306A. Rule 306A, whether by first-class mail or electronic means. Rule 36A says the notice must go to the parties or their attorneys of record, attorneys being plural, Rule 36A. In this case, it is undisputed that the clerk in Roberts County only emailed the notice of the judgment and the judgment to Mr. McLemore and Mr. Leon. The clerk did not email the judgment or notice of judgment to all attorneys of record as required by Rule 36A. That includes Mr. Garcia, who filed the original petition. And under Rule 8, it is technically the attorney in charge entitled to all communication notices.
Did you say that Mr. Garcia was not?
Was.
It's undisputed from y'all's point of view that he is the lead attorney.
That's an interesting question there, because we follow response. Mr. Leon was certainly, he's the lead attorney. But Mr. Garcia, Mr. Leon's the lead attorney, as we said in our motion. To be clear, Mr. Garcia filed the original petition. He signed the original petition. So under technical analysis of Rule 8, he's the attorney in charge, because there was never a later designation of a lead counsel. And I think that's important, because why should we require that the notices under 21A, which say every notice under these rules must go to all attorneys of record? Rule 36A says all notices of the judgment must go to all attorneys. Why require that rule? How would the clerk usually know who is the quote unquote lead attorney? I mean, all they would have would go back, unless there was a designation of lead counsel, you're left with the attorney in charge. But I think the better rule is send it to all attorneys of record. So we avoid mishaps like this, where one attorney, the email goes to a spam folder, or it gets lost, it doesn't get read. If it had gone to each attorney of record, the chances that all of them would have missed the email significantly decreased.
And I need to explore that for a moment with the language of the rule. And one of the problems of being on the road for oral argument is I don't have my rule book with me. That I always keep in my desk or in the drawer on the bench back in Waco. Is there a place in language of the rule?
Yes, but, and I can read it to you verbatim, well, not the entire rule. Texas Rule Civil Procedure 306A3 requires the clerk to, quote, give notice to the parties or their attorneys of record by first-class mail, end quote.
Okay, as I recall, in that situation, the clerk is trying to notify the attorneys for both of them, or all of the parties to the judgment. And I know this may sound nuanced, but it ties in the question of who is the not the lead attorney, the attorney in charge. Because another rule requires the notice to go to the attorneys in charge. Is that phrase in 306A, is it actually talking about attorneys or the attorney for multiple parties? If you understand my distinction.
Sure. And 306A really, candidly, doesn't really help us all too much, but 306A3, the specific provision we're talking about, says attorneys, plural. Now, below that, it talks about the motion, the party or his attorney is the language I recall, singular. So there's maybe a little conflict there. But we go back to Rule 21A, the notice requirement. Rule 21A says that every notice required by these rules, which would necessarily include Rule 36A, and in every pleading, plea, motion, other form, shall be served on the party, their agent, and or their attorney of record. So Rule 21A says all notices required by the rules, which would include 36A, has to be sent to each party's attorney of record. And if we construed that the rules as a whole here, if you look at, by analogy, Rule 165A, the DWOC notice, the DWOC rule, a trial sends its intent to dismiss a case for warrant of prosecution to each attorney of record.
So isn't that really a distinction in that rule where it clearly spells out that each attorney of record gets it, which is different than the lead attorney or the attorney in charge? If I use the word lead attorney, I apologize for that, because attorney in charge is the right term. And so doesn't that argue really against your position that the only attorney that has to be notified in this situation is the attorney in charge? Because in the other rule, it says each attorney of record, which is clearly different than the attorney in charge.
Correct. But I kind of disagree there. What if the issue is was the clerk required to send the notice of the judgment to the attorney in charge as defined by Rule 8? That would be Mr. Garcia, and it's undisputed that did not happen. I think the court's analysis is there. The Rule 306A motion should have been correct. There's no abuse. But we get into, I think, does the clerk have to send it to every attorney of record? I think it does. You read 21A, and I think that 165A is a good analogy for this case. Because we want to construe the rules as a whole, make sure they're consistently applied. And it'd be absurd for a trial court to have to send each attorney of record the notice of intent to dismiss, but not send each attorney of record the actual dismissal. And I think the other problem we have here is some of these bigger cases, there are multiple orders. Some sharing responsibility, some are sharing the workload, the financial risk and all that. I mean, how would the clerk know who is the lead attorney, other than the Rule 8, the technical definition of attorney in charge? So it's probably best practice to send it to everybody. And I think Rule 21A says that. Every notice required must go to the attorneys of record.
But isn't 21A a duty on the lawyers, and that is not a rule that is requiring notice by the clerk from the court?
No, I disagree with that. For two reasons. First, Rule 21A, let me find the language here. It again says, every notice required by these rules, comma. Doesn't say every notice required by these rules to be given by opposing counsel, or the court clerk, or the trial judge. It says every notice required by these rules must be given to the attorney's client. So I think that undercuts that argument that they try to make here, that this is only for parties serving motions. And up to Rule 21F10, this is where that conflict I was talking about earlier, 21F10 says the clerk can send a notice of the judgment, notice of the orders, electronic notices electronically. The clerk can send notices electronically. So we have the conflict between 21F10 and 36A3, which I think is the reason why the Supreme Court's amended the rule. But
Let me see if I can short circuit this. Do you agree that the attorney in charge was sent the notice electronically?
the notice of the attorney in charge under Rule 8, Mr. Garcia was technically the attorney in charge. He undisputed was not sent to the judge.
And then also you contend that it needed to be by first class mail pursuant to the rule, and he did not get that.
My initial thought was, yes, Rule 36A said first class mail, but going back and reading 25F10, and that said the clerk can send, the court can send notices electronically. Chapter 8 of the government code that was enacted after the rule, and reading the Supreme Court's amendment or proposed amendment of the rule, I don't think first class mail was required. So that's why I said I don't think you have to get it.
But you don't contend that he got it by first class mail.
Oh,
The first class mail was required. He did not get it that way.
if first class mail was required, neither side got notice of judgment by first class.
Okay. At this point, we need you to go past the jurisdiction. Let's talk about the merits.
Sure. So there's essentially three summary judgment grounds. The first one is the open and obvious. On the Cowboy Up's traditional motion, the only summary judgment ground they asserted about open in support of their open and obvious defense was that there was a missing handrail on the wall side of the staircase. Cowboy Up did not address the other assertions made by Ms. Korzinski as to why the staircase was unreasonably dangerous. That the handrail that was provided was too short, too far away, and too thick to hang on to. That there was a crack in the stair trail. The issue about the carpet being the wrong color, making it difficult to see the steps. About Ms. Milligan's testimony that the steps were quote unquote very steep, narrow, and little. Cowboy Up didn't address any of those other allegations or assertions in the traditional motion for summary judgment. All they addressed was the absence of the handrail on the wall. So for that reason, the summary judgment, as the traditional summary judgment, as open and obvious, must be reversed. Now, as to their no evidence motion for summary judgment on open and obvious, they merely asserted as a premises owner, Cowboy Up had no duty to warn Korzinski of an alleged dangerous condition that was open and obvious. As set forth in our brief, that no evidence motion for summary judgment was legally insufficient. First, open and obvious is an affirmative defense. Cowboy Up pleaded as an affirmative defense in their answer. I believe it's court record 10, paragraph 13, or court record 13, paragraph 10. They pled as an affirmative defense. It is well established that a party cannot move for no evidence summary on a claim or defense on which they have the burden of proof on a trial. Second procedural problem with their no evidence motion, they're saying there's no evidence of a duty. Well, whether a duty exists is a legal question, and the courts of appeals that have addressed this issue have said that a party cannot move for a no evidence summary judgment on a legal question or a question of law. Now, assuming they had addressed all of our assertions in their traditional motion, even assuming that their no evidence motion was, there's still a genuine issue of material fact about whether or not the conditions were open and obvious. Again, this is a summary judgment, reviewed to no deference to the trial court. All of Ms. Korzinski's evidence must be accepted as true. All reasonable inferences must be resolved in her favor, and any doubts about the evidence must be resolved in her favor. We presented evidence about the crack in the stair tread, how it could cause a tripping hazard. We presented Ms. Milligan's testimony about the steps being steep, narrow, and little, that she did not notice until after she went up and came halfway down the staircase. And we presented evidence about how the handrail that again was provided was too short, too far away, and too thick to hang on to.
Council, I think we're going to hear, I don't want to make the other side's arguments, but I need you to address them where they focus on proximate cause.
Sure. So in the approximate cause argument, essentially four arguments in support of the approximate cause summary. The first one is Ms. Korzynski doesn't know what caused her fall. As we started our briefs, our reply brief, our opening brief, our reply brief, that is not surprising. Ms. Korzynski had a traumatic event. She suffered a concussion as a result of this fall. She was taken from the scene by EMT, and she had surgeries afterward. That the fact that she does not recall how or why she fell is not dispositive. The second issue they want to raise is that they say Ms. Milligan observed Ms. Korzynski and said it looks like she just lost her balance. But I said, for our opening brief and reply brief, Ms. Milligan admitted she had no idea and no clue as to what caused Ms. Korzynski to fall. So Ms. Milligan's statement that it looks like Ms. Korzynski just lost her balance is no evidence, because she admitted she had no idea and no evidence, no clue as to what caused her to fall. The last two are more important. Throughout their brief, Cowboy Up says, in 22 years of owning this store, no one's ever fallen, tripped, or stumbled on our stairs, and no one's ever been hurt. That is inappropriate at the summary judgment stage. And why? What Cowboy Up is saying there, their Cowboy Up saying, no one's ever fallen or been hurt on our stairs. So you have to draw an inference that these stairs are not unreasonably dangerous. But again, this is a summary judgment. All the reasonable inferences must be drawn or resolved in Ms. Korzynski's favor, not Cowboy Up's favor. In fact, Ms. Korzynski submitted evidence that she had never staircase in her life. Applying their theory, their reasoning, the fact that Ms. Korzynski only fell down their staircase draws a reasonable inference that their staircase must be unreasonably dangerous. And finally, we have to address this result. The video issue is again asking this court to weigh the evidence, to look at the video and disregard Ms. Korzynski's assertions as to what the causes of her fall were. And I see that I am out of time. Reserve the rest of the time for rebuttal.
When you get up for rebuttal, I want you to address and focus on what you just laid out on proximate cause. 1, 2, and 3 is about the absence of evidence. And 4, I'm not sure, but this is a no evidence summary judgment that you had to bring forward evidence of a proximate cause for the injury, not a burden on them to prove that the stairs were not the cause.
To be clear, they did move for a traditional and no evidence.
Well, I'm focused on the no evidence summary judgment motion on proximate cause. And you've explained that the testimony about having lost or having no memory is no evidence of proximate cause. That the fallen and tripped on, that no one had done that in 20 years, that's evidence of no proximate cause. But what I'm trying to get to is it's important to bring forward some evidence that there was a proximate cause between the condition of the stairs and the fall. What you pointed out in 1, 2, and 3 is that they didn't present evidence or didn't prove in a summary judgment context proximate cause, but it's not their burden to prove it on a no evidence motion. It's your burden to prove the proximate cause.
Correct. The 4 items I was addressing was directly from their traditional motion, to be clear.
Okay. We'll need you to do the, no evidence on return. Counsel, you have 3 minutes to address the audience. You may proceed.
Thank you, Justice Gray. May it please the court. Ladies and gentlemen, can you hear me okay? All right, great. My name's Ian McLemore, my partner, Rowan Oliveris, and I represent Cowboy Up Ranch. A small mom and pop store in Calvert, Texas, that sells Western and ranch themed interior design items, couches, beds, knickknacks for the wall. In this case, it's alleged that they had an unsafe staircase that allowed for Ms. Korzinski to fall and hurt herself. But this is a premises liability case where, as you heard from Mr. Reagan when he was talking to you, into the court, where the plaintiff has to establish what actually caused her to fall, has to establish that that condition that caused her to fall posed an unreasonable risk of harm, and that we had a duty as the premises owner to make the condition safe. And as part of that, she has to prove the condition was not open and obvious because, as we heard earlier, there's not, for example, a duty to cover a hole that everybody can see. As you've heard, one of the big fact issues in this case is what exactly caused Ms. Korzinski to fall. The fact of the matter is, nobody knows. And that's the main reason why we're here, because nobody knows what caused Ms. Korzinski to fall. Much less that it was unreasonably dangerous. Nobody fallen on these stairs in more than 20 years. People used it all the time. The fact that goes to whether or not it's a possible contract would seem to suggest whether it's unreasonably dangerous. So that's why you hear this discussion about history of the stairs and unreasonably dangerous, because history provides some indication of whether or not the condition is unreasonably dangerous. That makes sense. If something has existed 20 years where people walk every day and nobody's ever fallen, that would seem to suggest that even if there's something wrong with it, it's not unreasonably dangerous. It does not pose an unreasonable risk of harm. And then finally, in order to somebody liable for negligence, you have to prove they did something wrong. And there is no duty in the state of Texas to warn anybody about conditions or to make safe conditions that everybody can see and know they're dangerous, like the big hole, the puddle on the floor that everybody can see, a blue puddle on this white floor out here, everybody can see it. Missing handrails, things like that. And so those are the factual issues that are important in this case. Chief Justice Gray, Justice Johnson, Justice Smith. I think the court hit on it. I think the Chief Justice hits on it in his questioning. The proximate cause is probably the key issue. It's the easiest issue to understand. It's the easiest issue that makes this case just positive. The fact of the matter is, nobody can say why Ms. Korzinski fell. It's just as likely that she lost her balance, that she tripped over her shoes, that she paid attention, as that anything having to do with the stairs caused her fall. We're not asking this court, we never asked the district court to be fact finders on this issue, but the court on a traditional motion certainly can consider the facts, and we asked it to do that. But even on a no evidence standpoint, they still bring forth nothing to say what caused Ms. Korzinski to fall. She doesn't know. And all her expert can say is, well, these things could have caused her to fall. The expert doesn't say they caused her to fall. The witness, her
Can
friend.
we not draw an inference from the expert's affidavit that the defects in the staircase that were identified do on the summary judgment, no evidence procedural standards, do we not draw an inference that those defects identify as the proximate cause?
No, Judge. There are several cases, including from the Supreme Court, Austin versus Kroger, is one. You can look at Barron case, both of which are cited in our briefs, where you have experts, plenty of experts, who opine on things that are wrong with a condition, but if they can't say what caused it, that is not enough. You have cases like the Hopper case, Hopper versus J.C. Penney, which oddly enough involves a staircase with a handrail that didn't meet code, it was obsolete. And there were a number of things that people were able to point to that could have caused it. The Fort Crockett Hotel case, a rail to a degree might not be code compliant. But in those cases, the courts and the Supreme Court in Austin and Moritz and Benson Ford, they talk about how you have to say what the cause was, and you have to prove that that cause posed the unreasonable risk of harm. It's not just enough to offer guesses about something to survive summary judgment. Summary judgments are routinely granted when nobody can identify what the actual proximate cause is in a premises liability or other negligence cases. This court has done that. And so while the expert can postulate on possibilities, the fact that Ms. Korzinski doesn't know and her friend who watched it happen doesn't know means that it's easy. There's no evidence to support proximate cause. And you can use the equal inference rule as well. When it is just as likely that there's some alternative explanation as there is some negligent explanation for something happening. The Supreme Court has said that applying that in the marathon case is a perfect example of this, that that is not sufficient evidence to support a proximate cause burden as well. So I think the court is right to focus on proximate cause because really it is the easiest way to dispose of this case on the merits. But there's also not an unreasonable risk of harm in this case. Like plaintiffs everywhere, the plaintiff in this case used an expert to opine on 4 conditions that pose reasonable risk of harm. The monotone gray carpet, the crack in the 5th step, their clutter on one side of the staircase, and the handrail issues. Well, in his affidavit, of course, we're not going to be able to question him on it. Could have said anything they wanted it to say to be able to support his opinion. He cites to no standards, no codes for the monotone carpet, for the clutter, or for the cracked staircase as his basis for saying it's unreasonable. Just because an expert says something is unreasonable, we all know that's not enough. An expert has to point to a particular statute, a code, some kind of safety standard. And the expert doesn't do that in his affidavit that's used in support of the response to summary judgment. The only standards he cites are with respect to the handrail. Now, the problem with that is this is a really old building, and there's nothing in the record to establish what, if any, building code ever affected this building. And what I can tell this court is in the briefing, because no building code ever did. The state in 2006 adopted the International Building Code, but these stairs were constructed long before that. The record shows that Holsey's opened Cowboy up in this building in the 90s at a time when no building code would have applied. Furthermore, in his affidavit, the expert does not actually say what standard does. He just says that there's a standard. I'll cite a specific standard that should apply to this building and how this staircase does not meet that standard. That's defective as to the unreasonable risk of harm as well. So while proximate cause is pretty easy, unreasonable harm is not that much tougher. Then we get to the issue of existence of duty, and Ms. Korzinski argues, and she's just wrong about this, that whether something is open, first that a court can't make a a legal duty exists, and use that as a basis for summary judgment. We can read Austin versus Kroger, a premises liability case, where the district court did exactly that. We can also read Austin versus Kroger, where the Supreme Court makes it pretty clear that there is no duty to warn about a condition that is open and obvious. And courts throughout Texas have routinely held that railings and handrails are open and obvious. The Hopper case, again, is almost exactly on point. You have a woman who was walking down the staircase at a J.C. Penney. There's a defective railing. Everybody admits it. And the Fort Worth court said that's an open and obvious condition. You've got the Crockett Hotel case. Got a railing. Everybody admits that it's defective. And the court finds that is open and obvious. Furthermore, what the facts show is that even if there was some issue with the handrail, it did not prevent Ms. Korzinski from using it when she walked up the stairs. It did not prevent her friend from using it when she walked up the stairs. And it did not prevent her friend from using it when she walked down the stairs. And Ms. Korzinski stood several feet away from it, didn't try to hold on to it as she walked down the stairs, and that's why she fell. She was tripped and fell. And so, you know, it is clear that to the extent there's a problem with the handrail, which again we can test, anybody else from ever using it. Moreover, as I mentioned to the audience, Ms. Korzinski misunderstands the point about there never being a history of falls at the premises. What courts have regularly held in a summary judgment context is that a lack of history of any falls is evidence is not unreasonably dangerous. It doesn't go to proximate cause, it doesn't go to duty. But courts have held that looking at the history is one of the things that courts can consider on summary judgment. And so the fact that no fall had ever taken place, the fact that we don't know how this fall actually occurred, what actually caused it, the fact that we have an expert who can't point to any standards that are actually, that apply to this building that are actually violated, and that for 3 of his standard plaintiff conditions, he can't point to any standard that's being violated. I think that makes the no evidence or traditional summary judgment pretty easy to affirm. Of course, that takes us to the jurisdictional issue. And to address the Chief Justice's question about the plural, the use of the plural attorneys, first and foremost, that word attorneys comes 2 words after the plural parties. I think it's pretty clear based on the plain reading of the rule, and that's so part 3.
Do you agree that the attorney in charge did not get the electronic notice?
I believe that the attorney, as defined by Rule 8, who was the attorney in charge, did not receive the electronic notice.
And you also agree that they did not get a notice by first class mail?
Yes, I agree with that.
Well, Counsel, let me ask you this on the question of electronic mail to begin with.
Yes, sir.
It's your position, despite what 306 says, which is mail, that Chapter 80 covers everything else. Chapter 80 applies to all civil and criminal statutes. Are the rules of procedure a statute or rules?
Rules are defined as statutes and as having powers of statutes, except to the extent that they are contradicted by later adapted statutes.
Well, if 306 was covered, why is the Supreme Court gone to amend 306 and add electronics in addition to first class mail?
Because, as the court knows, we all pick up our rules of civil procedure and we look through them, and the court wants to make sure that there's no conflict with those rules. In addition, the court has been ordered by the last legislative session to do just that.
For argument's sake, what if Rule 80, was 8.02 of the government code, what if it didn't apply? How would your argument flow then?
Well, then I would argue that even if you look at Rule 46A, different parts of it talk about notices or the notice envisioned by subsection 2, and it's not entirely clear that whether it's the sending of notice or the sending of a first-class notice is what applies. And so what I would turn to then are due process issues, and whether or not the notice that was given was reasonable to put Ms. Korzinski and her attorneys on notice that judgment had been entered against her. Yeah, we can receive first, stuff can be first sent from received. Stuff can be received in the mail and never read. We cite to a case where that's exactly what happened. And the Fort Worth court said, you received it, you never read it, you lose. The court lacks jurisdiction. And since we filed our briefs, the Eastland Court, Fort Worth Court, and I believe the 14th have all considered this issue under very similar circumstances. And they have found that it is the notice itself. I mean, there are knowledge issues, and I know that was addressed in back in December, but there are notice issues that as long as the notice was actually received, that is what matters, particularly from a due process standpoint. So if Chapter 80 didn't exist, what I would be talking to you about is whether or not the notice that was sent comported with the traditional notions of due process. And I would say certainly so. And I think the statute, I think the other rules, I think the rules regarding service of process between all it seems to support that same logic on the issue of due process. But if you look at the legislative history of Chapter 80 as well, it makes it clear, speaking to Justice Smith's point, that the intent is to cover anything that could or is required to be sent under any statute or any rule. They refer to judgments. You can look at it's part of our summary judgment evidence. It's in the record. But you look at the bill analysis that came out of the committee, where it talks about the fact that specifically in instances like this, email notice is supposed to suffice.
If where are the rules of civil procedure defined to be statutes as contemplated by the code that Justice Smith wrote?
It's in some cases, I can provide that to the court. I don't know off the top of my head. I'd be happy to submit a letter brief with that authority to the court before the end of the day on Friday. I will do it before the end of the day tomorrow. I'll be out there tomorrow.
Well, Friday's Good Friday, so let's make it Monday.
Even better. Thank you for that, Chief Justice. The other issue with respect to the notice in this case that I believe is important is the fact that it was sent by the district clerk the very day that the judgment was signed, and the judgment was filed that day with the district clerk. This is not an instance where a court coordinator sent a notice, and that's important because if we receive as attorneys an email from a court coordinator, that might provide some idea that something's happening in your case, but we all know by rule, the judgment's over. So if you're receiving something from the district clerk as opposed to a court coordinator, that should put you on notice that something's going on in your case. So I think that is an important distinguishing fact, particularly between this case and this court's opinion back in December. And this court didn't address the issue of whether a coordinator was a clerk or not, and that opinion didn't even reach it. The other thing that is important is the fact that on that date, it was available for anybody to go look and see what happened. Again, that was an important distinction between this instance and the court's opinion in December. So, you know, there's some really easy ways for this court to resolve this case. Proximate cause is obviously the easiest reason why the court's going to end on it. There simply is no evidence of what caused her fall. If you go home tonight and talk to your family about what happened today, and the fact that you can't say, no, all you can do is guess at it, and that's no evidence of anything. Certainly no evidence of proximate cause. I'm out of time, and I'd be happy to entertain any additional questions the court has.
Thank you, Counsel.
Thank you.
Counsel, you may proceed when ready.
Barely for 30 seconds to talk about proximate cause for the benefit of the students. As the court well knows, there are two elements to proximate cause. It has to be, the event has to be reasonably foreseeable, and the event itself has to be the but-for cause of the event. But there are also some additional rules. The first is there can be more than one proximate cause of an injury or an event. That's well established, reams of paper on that. And additionally, at the summary judgment stage here, this court is not required to negate all causes, all possible causes of her fall. Now, to get to where you want us to focus on here, the proximate cause. The first issue, was this injury, was this event foreseeable? What we have here is an unreasonably wide staircase in an old building. And the evidence shows, at least a genuine issue material fact is this, that Cowboy Up knew that such a fall would be foreseeable. Now, how do we know that? We know because on the side without the handrail, Cowboy Up put all that merchandise on the staircase to force customers and force its employees to the side with the handrail. It said the second floor was off limits. The Cowboy Up owner said generally people don't go up and down the stairs. The salesperson has to escort a customer up and down the stairs whenever they do go. Customers are not allowed to go up there. That shows foreseeability. Of course, it's foreseeable. The basic premise is foreseeable that a person could fall down, trip, stumble, and fall down the stairs. But they had the foresight to see, hey, there's not a handrail on this side of the wall. The person who trips, stumbles, or falls down the stairs is not going to be able to have the ability to reach across. So we're going to put all this merchandise here and force these customers over to the side with the hand. So that shows that at least a genuine issue material fact that exists that whether or not Cowboy Up knew this was foreseeable. Under an unreasonable danger caused by this unusually wide staircase with its steep, narrow, and little steps. Now, for the but-for cause, let's put aside the cracked stair tread for a second. Let's put aside the car. Let's just assume Ms. Korzinski simply lost her balance. Again, that's foreseeable that a customer or anyone could lose their balance walking down the staircase. I almost fall down my stairs once a month. But the issue here is what for cause that because they didn't push the customers over far enough to the sidewalk, that they didn't warn customers to stay right, that someone who could stumble, trip, or lose its balance would naturally reach out for a handrail to break her fall. And this handrail, again, was too short, too thick to grab, and more important, too far away. This is no different, this defective handrail is no different than uneven stair treads. Each stair has to be the same height, 7 1/4 inch, whatever it is, but it has to be the same height. As you walk down, your foot naturally progresses and has a feel. If the stairs are uneven, one's 7 1/4 or one's 9 inches, that's a tripping hazard. And that they provided a stairwell that's too far away is no different from an uneven stairs. So we have the foreseeability for approximate cause. that these folks at Cowboy Ranch knew the staircase was too wide. They knew the handrail wasn't on that side, and that they needed to push their customers to the side of the handrail. And then we knew that much there, they told their customers not to go upstairs unless they were escorted. And we have but for at the very minimum, because it was foreseeable someone could trip, stumble or fall, and it was foreseeable they would reach out and grab a handrail. But that handrail in this case was simply too far away in this unusually wide staircase. So to answer your causation question, that's our best argument. We also have the stair tread, we have the carpet issue, we have the distraction, but that's the easiest way home for us. It's certainly foreseeable someone will trip, stumble, fall, and try to brace their fall. There was a handrail that's simply not there. Now, to circle back very quickly, make sure I didn't miss it for a second. To the, I'm out of time, sorry.
I'll give you a sentence or two.
I was just going to say on the jurisdictional issue, there are other rules of civil procedure that specify what notices have to go to the attorney in charge, which is 21C. And there's some other rules in addition to Rule 8. The Texas Supreme Court, if they intended Rule 36A to say attorney in charge, or they intended Rule 21A to say attorney in charge, that all notices must go to the attorney in charge, the Texas Supreme Court certainly knew how to do it because they did it in other parts of the civil procedure. Those two rules are crystal clear. They say attorneys of record, and it's beyond dispute that while there can only be one attorney in charge, there can be multiple attorneys of record. And as in evidence this case, we have 8 attorneys that get notices from this court every time they say. Thank you for your time and thank you for having us.
Thank you, counsel. This case, you got a letter brief due. If you cited any cases that were not included in your brief or statutes or rules, you'll need to include those in the letter brief as well. And by Monday next week is fine. And Council Leon, don't worry about the phone. I forgot to announce to everybody to turn their phones to the off silent position. That's a standard SOP that I do, and I forgot.
It was on silent, Judge.
Now I remember more.
That was an alarm that went off, but I didn't know it was on, so I apologize.
No problem. Y'all have been submitted, y'all are excused. And we're gonna just stay on the bench rather than retire unless pretty good. Okay, we're gonna go right into the second case, so we'll give y'all time to move around.